responses. I had a chance to review all of those things prior to the hearing. The legal positions of all parties and the actual background, of course. We've had a lot of hearings in this case over the years now. So with that all being said, Mr. Dibb, any oral argument you wanted to present in support of the motion?
Yes, Your Honor. Thank you. May it please the court, Your Honor, good afternoon. The case is scheduled for trial May 11th, 2026. And if I'm not mistaken, this is the first trial date that has been assigned to the case. There have not been any other motions filed to adjourn the case for the obvious reason that this was the first trial date. We facilitated the case with Mr. Beam on February 13th. The case did not resolve, obviously. Given the complex nature of the case, the number of witnesses and experts, it's going to take at least 2 weeks to try this case. We have a conflict. It's Lansing and Ingham County, Hannah versus Advanced Vascular. That's another complicated malpractice case. That was adjourned to a date certain, May 4th, just before this trial was scheduled to commence. So that case is going to take at least 2, maybe even 3 weeks to try. So given all of these circumstances, we would respectfully request that the court reschedule the motion or the trial. I did have an opportunity. There is one objection to this motion, citing the inconvenience of the parties and witnesses. Well, and that would go both ways, because we would also have to incur that same inconvenience for our witnesses and the experts. So given this, we would ask that the court in its discretion adjourn the trial to a date that we can agree upon. Thank you, sir.
Thank you. Mr. Busker, anything that you want to state?
Just briefly, Your Honor, obviously we filed a response opposing this motion. This is a problem that's going to happen no matter when the trial is scheduled. I know our office has also sent a trial conflict letter. We have another trial, or maybe 2 now, that conflict with this trial, but that will keep happening, right? Our law offices are busy. We have trials scheduled. If you look at the trial schedule coming forward for plaintiff's counsel, it looks similar to ours. Every month we have a few trials. Most of them end up moved, adjourned, or settled, but some of them have conflicts. From our perspective, this is the oldest one. This one's the most significant as far as the preparations that our clients have put in. This trial was also set quite a ways in advance to try and avoid these issues to begin with. It was scheduled almost a year out, looking at schedules back then, looking forward. And so particularly here for Dr. Lagatuda, Dr. Schubert, and Dr. Leorden, and what they have to put into putting aside 3 weeks like this, we'd ask the court to keep this trial date and that we move forward with it.
All right, thank you.
Thank you, Your Honor.
Mr. Controni.
Your Honor, I have nothing to add. Leave it to your discretion. However, my June is wide open.
Counsel, anything further?
The only thing I would add, Your Honor, is as much as being about 4 weeks into this case, as much as I would benefit from the additional time that adjournment would offer, I think Dr. Atchison, who is no longer at the University of Michigan and has endured obviously inconvenience and hardship to take the time off associated with this trial, I think it would be his preference that it stays where it is.
So obviously I took a look at the kind of the procedural history of the case. Mr. Dibb's correct. There haven't been any prior requests for adjournments or scheduling of trials or adjournments in the case. Mr. Dibb's correct in terms of the standard. This is a matter that's within the discretion of the court. And the court certainly acting within the exercise of that discretion in ruling on the motion. Some of the factors that the court is to look at are how many previous adjournments there have been, whether those have been at the request of the moving party or other parties, whether the adjournment is being requested because of some kind of an undue delay or lack of diligence on the moving party. What kind of prejudice would result to either side if the motion is granted or not granted. Those are the kind of things that case law is outlined. The courts are to look at when determining whether an adjournment is warranted. In this case, I think one of the major factors is the age of this case. The case is now close to 5 years old. It's taken us a long time and many hearings to get to the point where we were ready for trial. So in relation to some of the other cases that plaintiff's counsel has scheduled, this is certainly much older than those cases. Another, I think, driving factor to me is the amount of time. If this was a 3-day trial or something, it could easily be rescheduled. Because it's a multi-week trial and because this is a multi-county circuit, getting enough courtroom time here in Crawford County means that I have to take time away from other judges. They have to adjust their schedules. So it's a much more complex and difficult matter to reschedule and to get it on the books in the first place than it might be in other jurisdictions. I also look at the amount of time that we've had since the trial was scheduled, and I believe we set the dates last June. Is that right?
No, and yeah, it's June last year.
So, I mean, when we discussed trial dates in June, it's taken us to May, so almost a year to be able to get the trial date, which means we're looking at likely at the very best late 2026, but more likely into 2027, which then puts this case close to a year from now. Again, I'm confident that to the extent that other cases might need to be adjourned or counsel's other May case, I'm more than happy to communicate with the courts and explain all of those circumstances. And knowing my fellow judges as I do, I think, particularly given that that case was scheduled after the trial in this case, confident that other judges would see this as having priority. And so for all of those reasons, the court finds that adjourning the case at this point would result in undue delay. This case is going to go to trial. It needs to go to trial as opposed to waiting another year. So although I don't find that any of those factors are that I've listed come into play, certainly this is again the first adjournment. There hasn't been any delay at all, in my view, by the plaintiffs or any kind of lack of diligence or anything like that. This appears to be a purely scheduling matter. But for all the reasons I've stated, I find it would be inappropriate to adjourn and try to reschedule. And Mr. Dipp, any assistance that you need from my court, communicating or working with the other courts, I'm more than happy to reach out and do whatever it takes.
Thank you, Your Honor. I just, if I'm in Lansing trying this other case, which is likely to spill over to the start date of our trial, what am I to do?
Well, what I'm suggesting is I can communicate with the other court and let them know and ask them to adjourn that trial date.
Should I then give you the information of that case to your staff?
Yes.
Okay. All right, very good. Thank you for that. I appreciate it.
Because I agree. I mean, I would not want you to start that trial and then try to move over to this case. I promise.
I'll get that to you right away.
Yeah, okay, thank you. And Mr. Dibb, if you would prepare an order that reflects that rule.
Yes.
Forward. The next matter that we have up is plaintiff's motion for relief. And again, I've had a chance to review the briefs of the case. And I can say this is an issue. I've got another case in Otsego County. Similar issue regarding prospective damages for for the child plaintiff. In the Otsego County case, it wasn't a death and the child was already born. But we've addressed this issue, so I'm kind of familiar with this kind of argument between plaintiffs and defendants over these types of damages and whether they're speculative, whether the plaintiff should be allowed to present them. So I touched on this, and I was aware of the ruling when it came out because of those other cases, my other case. So I'm familiar with the issue, but Mr. Dibb, certainly if there's anything that you want to state in response to what the defendant's replies were to your motion.
Yes. To that end, address some of the things that they raised. So, in reviewing the defendant's responses, the common theme is that, well, every argument that they raise is built on this legal foundation that no longer exists via the DeMott case. The court, in its order, rested on the Zahill and Sutherland case, and the exact reasoning that DeMott has squarely rejected the reasoning in Zahill and Sutherland. So all three defendants have argued that that DeMott doesn't apply, doesn't change anything. And my response to that would be DeMott directly holds that an infant decedent household services damages claim is not barred as a matter of law. The court's prior ruling that was issued used the same two speculative reasoning that the DeMott case expressly rejected. This other argument that's been raised by the defendants that DeMott is only about infants, not unborn babies, is likewise meritless. Medical definitions have zero relevance to the statutory wrongful death damages. And in this case, a baby of 34 weeks gestation is considered viable and has a standing to bring a lawsuit. Defense also claims that DeMott is on appeal and that the trial court should not follow it. This was raised by all three defendants, all three groups of defendants. But I would remind the court that a grant of leave by the Supreme Court does not vacate or diminish the Court of Appeals opinion, and that the trial courts, like yourself, must follow the Court of Appeals authority unless reversed or unless it was expressly stated by the Supreme Court, which it was not. So, in my opinion, ignoring DeMott would itself be reversible error. Defendants, this was raised by Munson. Munson raises an argument that Daher limits wrongful death damages and that household services are not allowed. But DeMott thoroughly analyzed Daher and held that its reasoning does not eliminate household service damages. In fact, household service damages have been recognized in the hundreds in every version of the Wrongful Death Act since then. Daubert did eliminate the lost earnings capacity, but not loss of services. That's a distinction that DeMott expressly made and emphasized. Defendant Munson and Eaton, EPMG, both defendants raised the argument that the heirs, in this case, the heirs at law, family, testified that they never expect support, therefore there was no pecuniary loss. But again, DeMott expressly recognized a specific exception for infants. The reasonable expectation support test in the Thompson case does not apply when the decedent is too young for such evidence to exist. And this argument that's been raised by Munson and Eaton simply repeats the exact rule that DeMott expressly rejected. So expectation testimony is irrelevant under the controlling rule for baby deaths or fetal deaths. Defendant Eaton, I touched on this at the beginning. Defendant Eaton argues that that Clarissa was a fetus, unborn versus an infant, so DeMott doesn't apply. And again, the Wrongful Death Act makes no distinction between fetuses and infants in terms of damages. Michigan law has long recognized wrongful death of fetuses, and once within the Wrongful Death Act, the damages framework is identical. There is no distinction in the law between unborn babies and babies, about unborn viable babies. The reliance that defendants have on pediatric definitions, again, is legally irrelevant, right? The statute is what controls, not any medical classification. No doctor is going to take the stand and say that Clarissa was not viable at 34 weeks, 35 weeks gestation. And the core principle in DeMott applies with equal or greater force in a situation like this. The younger the decedent, the more essential it is not to penalize plaintiffs for lack of individualized data. There was all three sets of defendants argued that experts' opinions in this case are speculative, that the assumptions are unrealistic, and the averages are improper. My response to that would be that DeMott explicitly held that infant decedent damages will always involve uncertainty. This does not bar recovery in a case like this. These go to the weight, not admissibility. The defense attacks assumptions, but it ignores that, number one, for example, Dr. Paranjape, our economic expert, economist, PhD economist, used a standard methodology. He used what was referred to as ATUS hours, Michigan replacement cost rates, and statutory discounting. Ms. Pasikowski, the vocational rehabilitation expert, provided the vocational and educational underpinnings that DeMott expressly approved. So if the defense thinks that the numbers are high, their remedy is to cross-examine these experts and not categorically bar them from testifying. Dr. Eaton in particular raised another claim that the experts didn't provide opinion specific to Dr. Eaton. The baby was dead on arrival. But that is a causation argument. That's not a damages category argument. 2.612F concerns whether a damage category was improperly barred, not whether a particular defendant caused the death. So liability disputes go to the jury, not preclusion of statutory permissible damages. Munson raised this claim that discoveries closed, reinstating damages now would be prejudicial. And in fact, no additional discovery is required. Both experts were fully deposed before your ruling. Defendants had full opportunity to challenge the methodology. The only thing that has changed since that time has been the law, not the evidence. So correcting what I believe is a legally invalid order at this time, right? Because of it's not prejudice, it's compliance with it's now a binding precedent. And then the defendants lastly claimed that plaintiff's motion untimely barred is untimely barred under 2.612F. 612F provides that it's appropriate when binding law changes after the court's ruling. And we file this motion, there are extraordinary circumstances that exist because the current order that the court rendered is now invalid, and it would force an erroneous trial on damages. The failing to apply binding precedent is itself an extraordinary circumstance. There was one last claim that all three defendants raised, that the plaintiff has no evidence supporting household services damages for Clarissa. And plaintiff specifically supplied exactly the type and the quantum of evidence that DeMott requires: economic analysis, estimating household service hours, localized replacement cost data, household services benchmarks, life expectancy tables, and vocational evidence of family education trajectory. DeMott, such evidence provides some degree of loss, quote unquote, and there's enough to reach a jury. So, Your Honor, defense arguments all share the same flaw. In my opinion, they asked this court to ignore the precedent. DeMott rejected the infant speculation rule, rejected the reliance on Zahill, rejected applying Thompson to infants, and reaffirmed that household services damages remain available under the Wrongful Death Act. And we have produced the exact type of evidence that DeMott requires. So pursuant to 2.612F, we respectfully request that the court reverse its prior decision in that regard.
So just one question.
Yes, Your Honor.
Would you agree or disagree that that DeMott doesn't change the general framework for determining whether damages are speculative or not speculative? The real applicability of the finding in DeMott to our case is that it allowed for those types of damages for an infant. In other words, the factual similarity between DeMott and our case, not necessarily a change in how the court should analyze those kind of damages as a framework that the other courts have set forth.
Well, I think DeMott recognized in this type of case that there will be some element of speculation.
Correct.
That we can't argue with that, right?
Sure.
And the experts,
But
and this is where the
those other courts have also held that, right? Like
Yeah.
that generally damages can't be determined to a mathematical certainty in all cases, so there's always the possibility that there's gonna be some uncertainty, and that didn't really change with the DeMott ruling, but the thing that really changes our case in light of DeMott is the fact that that court applied it to an infant circumstance.
Right, but that should not alter the reasoning to this case. The fact that Clarissa hadn't been born yet does not negate the right that she has to damages. This unborn child is still entitled to the same damages that she would have been entitled to after she was born, and she'd been allowed to. I don't know if that answers your question.
I think so.
I appreciate your input. Thank you.
Okay, thank you. All right. Want to go first?
Sure.
You guys talked about who wants to address. First, but feel free, please.
Thank you, Your Honor. I understand that you're familiar with the case and that you reviewed the brief. So I'll just hit 3 points. The first one is the standard for this motion for relief from order. This isn't re-arguing a C10 motion. This is under 2.612 C1F, requires extraordinary circumstances and references improper conduct. That's not something that we have here in either case. It's our position that DeMott does not change the ruling here. It doesn't change the law here. And it's important to compare this court's order and what was actually argued back in 2023 and what DeMott found. Because in the interim, Daher came out, and from our perspective, Daher completely bans this type of claim, period. But this court issued its order pre-Daher. So when DeMott's coming in, DeMott's trying to, from our perspective, thread a needle to get around Daher and say this is there. We expect that to be decided in this Supreme Court term. It's up on the Supreme Court. But that wasn't what this court found back when these damages were dismissed. The footnote from page 3 of this court's order says, none of the defendants have argued the Wrongful Death Act in and of itself does not allow for recovery of damages to a child decedent's loss of future earnings capacity or loss of future household services. So DeMott came into a circuit court that had determined that that was true, that the WDA prevented these damages completely. That's not what we have here, and that wasn't the basis for this court's decision. And so that's what DeMott was coming into, and it's not what we have here. This court assessed the speculative nature of the damages, in this case, with the evidence that we have here. And that's the other huge distinguishing factor between this case and DeMott. DeMott uses two double negatives, right? It says we decline to disallow requested loss of services damages at a matter of law at this early point in proceedings. We're not in an early point in proceedings. We have testimony of the parents. We have testimony of these experts. What the evidence that's before the court, and even the evidence that was before the court back when this order was entered, was substantially more than what the court in DeMott was looking at. And as the court's question just referenced, assessing whether damages are too speculative to go to a jury hasn't gone away with the decision that DeMott made. The panel in DeMott was determining that the trial court could not, as a matter of law, say these damages are never allowed. The last footnote to DeMott even says, we offer no opinion about this report beyond noting that it's been provided and it supports plaintiff's claim. The defendants moved for summary disposition shortly after it was produced. That case was early in discovery. It wasn't where we were, even when this case was ordered, and certainly isn't where we are now, where the evidence has been presented to the court, and here not enough has been presented. I agree that there's case law discussing mathematical certainty. That's not what we have here. We have whether there's any expectation of loss of services at all, not the exact amounts they're worth. We certainly disagree that that can be proven, but just whether they would be provided, period, and to any person. That hasn't changed. That's the same in 2023 as it was now, and DeMott didn't overrule that either. When we get into what the court talked about, it didn't get into that evidentiary assessment because it was just looking at this flat question of, is it allowed under the WDA or not? That wasn't the basis for our motion back in 2023, and the court's order is very clear that that's not the determination that this court made back then. We looked at whether there was anything to even hit that basic threshold of not being too speculative to go to a jury. That's still true here. I have to mention Dr. Pezikowski. She was deposed a year after that order came. These damages were not pending when she was deposed, and that addendum to her report has absolutely nothing to do with Clarissa's damages. I quoted in our brief when we were asked, okay, and give us, what does this mean? What does this addendum mean? And her response says, well, for the child care for Carter, there'd be 2.7 hours per day. Is very clear that she's talking about Cassidy only and what care Cassidy would provide to her living son. She was not saying, oh, Cassidy and Clarissa, one or the other might be providing care to their son or brother. That's not what that report was. And it was, her deposition was taken when these damages weren't pending. That's not what she's talking about. And I have to mention here and preserve for appeal, Daher controls here. To the it would remain our position that, say those damages had been pending, this order hadn't been entered back in 2023. After Daher came out, we would have then needed to move under Daher to say these are completely disallowed under the WDA. From our perspective, DeMott is contrary to what the Supreme Court had determined in Daher. It doesn't control in this case, but we don't have to get there in order to deny the motion that we have before the court today. Because what DeMott found and the evidentiary basis that DeMott was talking about is different than we have here, and does not overturn or change the ruling that this court made a couple of years ago. Unless the court has any questions. That's my argument.
I do not.
Thank you, Your Honor.
Mr.
Thank you, Your Honor. I'll try to keep my comments or statements brief, but let me just first start by this whole viability issue that Mr. Dibb raised in his motion. My client, Dr. Eden, sits in an entirely different position than the OB-GYNs and Munson, except for Al Munson's vicarious for Dr. Eden. Dr. Eden's coming in 38 minutes after Clarissa and Cassidy die. At home, it takes 38 minutes for them to get to the hospital before my client even becomes involved in any aspect of these plaintiffs' care. Plaintiffs' own experts, the maternal fetal medicine expert, Dr. Caldwell, the emergency medicine expert, Dr. Nelson, and their family practice expert, Dr. Tucker, all admit Clarissa, the baby, is dead before she gets to Munson Greeley, before she gets to Dr. Eden's care. So if we want to go down this course of viability, his own plaintiff's experts admit Clarissa was not viable before she got to Dr. Eden. What is also important is from a causation. So you can take Dr. Eden entirely out of this whole DeMott conundrum we have right now with it being up to the Supreme Court, because it's a causation argument. As Mr. Dibb recognized, it's a causation argument. When Clarissa is not viable, she's dead on arrival, there is nothing Dr. Eden could have done to change the outcome of this case. There cannot be any damages related to Clarissa related to his care. It's simply a causation argument. We don't even have to get into speculation of what Clarissa's going to be like at 18 and who might rely on her or not. Because all we have is, we know Clarissa is dead. And if this was just a case about Clarissa, Dr. Eden would be out because the experts do not support any causation or cause of action against Dr. Eden in regard to Clarissa. Cassidy is an entirely different thing at this point, and we will be in trial for 3 weeks over a part of that. But from Clarissa's standpoint, she is dead on arrival. There is no causation for any of her damages. The whole, I think this expectation of, when we go through with the family members and all of them confirmed, we didn't expect her to do anything for us after she turned 18 or at any time. That's a causation argument as well. If the estate, the heirs of the estate, and that's what these lost household services are supposed to be under the Wrongful Death Act, as it stands now, it's what services she would provide to her heirs. Her heirs of the estate said, we're not expecting anything. So where's the causation for this damage? There is none. If mom comes in and says, well, I'm in a wheelchair and I'm expecting that my kids are going to raise or support me, that's entirely different. But there's none of that here. There's no causation for lost household services related to Clarissa. And as I pointed out, parangipy is 3 to 4 hours a day, every day of Clarissa's life after she turns 18. That in and of itself is speculative. that is an unreasonable opinion. There still has to be some reasonableness to the opinion. And when you say an 18-year-old kid, I have a 20-year-old and a 16-year-old, they don't do 3 or 4 minutes of household services, let alone 3 or 4 hours. But to expect that Clarissa's going to go to college and then come home and work for the family for 3 hours and then do her homework and then do her studying and get ready for exams and things, it's just ridiculous. And I pointed out in my brief, I mean, on her wedding day, is she going to stop and do 3 or 4 hours of services for the family? When she's on her honeymoon, is she going to come back and do 3 or 4 hours a day? Parangipi, his whole job in this case is to just maximize those economic damages. And, you know, as Mr. Buskar pointed out, we took these depositions while this claim was dismissed. So I think if the court is inclined to reinstate them, number one, I don't think they should be reinstated for Dr. E. But number two, if they are going to be reinstated, I think we need to have an opportunity to go further and redepose these experts on this issue. Thank you, Judge.
Thank you, Mr. Miller.
Judge, my colleagues on the defense side have done a tremendous job of arguing this and reasoning it, so I just want to stress one thing. From my perspective, I think the distinction between a born living infant in DeMont and an unborn fetus, which was at 32 weeks, is huge. And I think that is too much of a hurdle for plaintiff to overcome. And to extend these damages to an unborn fetus, I think creates an incredibly slippery slope, such that, does that mean that at conception, parents would be entitled to household services for their 1-week-old, 2-week-old, 3-week-old fetus? Mr. Dibb said, well, we shouldn't be getting into medical definitions, but then hinges his entitlement to these damages on this concept of viability. So does that mean every trial court then has to wade into this analysis of, was this a viable fetus? And we're taking either expert opinion testimony, or we're talking about when you can hear a heartbeat or when they would be viable outside of the womb. This is a dangerous, slippery slope to go down. And I think we have a clear, easy distinction between the issues in this case and the ruling in DeMont. And it's the difference between an unborn fetus and a living baby. Thank you.
Did you have any responses you did?
I do, but I get a feeling the court has heard enough.
I mean, if it's
I was just
different than what you've already.
No, I think it would involve the same. I anticipated what defendants were going to argue, and I think I addressed that when you asked me to the podium, so we're fine. But I'm a little disturbed by the last argument that an unborn baby is not entitled to damages in a case like this. The law has already recognized that. That's not even an issue. If that were an issue, then there would have been a motion filed that we have no standing because we don't have a human being to represent in a wrongful death case. That motion never came. The obvious reason it would be meritless. Thank you.
All right. I do want to take just a quick break. There's something in the file that I want to review, and then I'll be back in the record. So it's sometimes happens even when the parties have done a good job of briefing the issue, which both sides have done in this case. The oral argument raises a question, something that I want to investigate further. I was going to try and do it here, but I've got a docket to move on to, and I'm not going to be able to give it the appropriate consideration that I'd like to give it. So I did have a criminal trial next week that came down, so I'm going to be able to get this out to the parties quickly. The ruling on this motion. I intend to do that early next week. And then in light of that kind of being an outstanding issue, and I would like to, Mr. Dibb, get that information, provide that to my office about your trial in May. I'd like to have an opportunity to communicate with that court. So rather than going forward with the status conference today, discussing kind of what I intended to discuss about the trial, which is jury instructions, jury composition, voir dire, just kind of our daily trial schedule and all those nuts and bolts of trial. I'm going to set this for another status conference in April. We can do it by video so that everybody doesn't have to drive here, so that we can go over those things. By that time, I will have been able to communicate with that other court. Parties will have a decision on this motion. And I think we'll be in a better position to hammer out trial details. So that's how we'll proceed. Mr. Dibb, anything else? That's counsel.
Your Honor, my only question is if the court normally has a date certain for motions in limine in advance of trial. I know some judges do it a few days before, some set it 3 weeks before trial or something like that. And if it's going to be that far in advance, then I'm not sure a status conference in April would leave enough time for it. So
Sure.
That's my only question.
It's a good question, and that's something that we would have addressed today. We'll address that in the order that I get to the parties and ruling on this motion. But I'll build in enough time so that we can address them.
Thank you, Your Honor.
I mean, are you anticipating a lot of motions in the day?
Probably.
We're defense lawyers. Of course, there's gonna be a lot of motions.
And that's fair. I find generally that a lot of motions eliminate, and it's, I'm not saying not to file them, but a lot of them end up being kind of things that the court can't rule on until the time that the evidence is presented, the posture of the case at that point. But I'd like to get them early because then I know at least can anticipate what the issues are going to be before trial as well. So I guess I'm just talking to myself here. Take that for whatever it's worth. But I will address that.
Thank you, Your Honor.
Sounds good.
All right, thank you.
Thank you, Judge.
Can just wait, I'm just gonna throw it in that box and then I'm gonna catch all of you out in the lobby. Or-
Good afternoon, Judge.
Thank you. Thank you. Safe travels.
What are you doing here, Brian?
Gonna call you guys out for that.
This is funny. How about you just come and sit in my office with me, Greg? We'll do this
Yeah,
together.
yeah, we can do it together.
Okay, which counsel are here on the Sherry Powers versus Burke case?
That would be me, Your Honor.
Okay, Ms. Piper or Mr. Light, are either of you here on that case?
No, Your Honor, we're here on the Michael Paley case.
Incidentally, my opposing counsel on my Sherry Powers case is Dave Carbajal, who works with Kalen Piper.
Yes,
Yeah,
that's
so-
correct.
Ms.
Oh.
Piper, you're not appearing on the Powers case, though. You're on the other one.
Yeah, I believe Dave should be here. Yes, there he is.
Okay.
Yeah.
Good afternoon.
Oh, look at the man, the
There
myth, the
he is.
legend. How you doing, Dave?
All right,
Well.
guys, we are on, hey, counsel, we are on the record, so just
Oh,
watch what you're
apologies, Your
saying.
Honor.
That's all right. I don't mind a little informality, but I just want to make sure you know you're on the record here, and we're broadcasting to YouTube, so.
Oh, I won't
Alright.
say anything else about Dave, I promise.
We're on the record in Sherry Powers versus the state of Foster Burke. This is file number 2511999. If I could have the counsel appearing on that file, place your appearances on the record, please.
Brian Zaid on behalf of the plaintiff, Sherry Powers.
David Carbajal on behalf of the estate of Burke.
Okay, and we're on the record today for purposes of a status conference in this file. Mr. Zaid, can you tell me where things stand today and what you'd like to see going forward in terms of scheduling?
Judge, we're in a really good position right now with almost all of the depositions that might be necessary in discovery scheduled. Plaintiffs, defaulted defendants, and witnesses all scheduled probably by the end to be done by the end of March, permitting that there aren't any rescheduling issues. And maybe a couple after that may be revealed through. I don't know if I can tell you I don't anticipate it or not. You never know what happens, but we're on a good path. And I think if we were to be able to have those completed, I think we should have a pretty normal scheduling order. I don't know if Dave would agree or not, but I'll turn it over to him.
Have the parties mediated yet in this case?
No.
Mr. Carbajal?
Yes, Your Honor, if the court would allow discovery of 6 months, and I'd like to reserve IMEs. Deps are scheduled this month and in April. And I anticipate there's a potential for motions thereafter. And of course, I am still getting most of the plaintiff's medical records, but we are moving on it.
Okay, Mr. Zaid, do you have any objection to that,
Nope.
those suggestions?
Nope, not at all, Your Honor.
Okay, do the two of you think that you'd be able to agree on a mediator?
Yes.
Yes, Your Honor.
Okay. So, and do either of you have an objection to having mediation, if we have a 6-month period for discovery, having mediation no later than 30 days following the close of discovery?
That would be fine, Your Honor, although I believe we'll probably get it done before that.
Sure, and I'm just talking about a cutoff period. For the parties are free to schedule that whenever they feel they're in a position to be able to meaningfully participate.
Sounds good to me.
Okay, and Mr. Zaid, is there any need to add any parties or amend your pleadings at all?
I don't believe so. I
Mr.
think the
Carbajal?
pleadings are satisfactory in terms of who I've named. After the depositions, there might be, like Dave said, there might be some motions or something to discuss regarding other factors that should not affect pleadings, actually. But we're fine.
Okay, all right, thank you. Mr. Carbajal?
I agree with that, Your Honor.
All right, and either of you have an objection to a motion for summary disposition cutoff, also 30 days following the close of discovery?
That's fine for the defense, Your Honor.
That's fine for plaintiff as well.
All right, so I will send out a pretrial order that will reflect the dates that we've discussed here today. I will also set this for a status conference at the close of discovery or at the time of filing of a dispositive motion. And the court will also provide in that pretrial order that the parties are to confer and agree on a mediator and just notify the court of your selection in writing within the next 14 days. And then we'll have that status conference at the close of discovery. If the case hasn't settled through mediation by that point, we can discuss whether the parties want to engage in further ADR or whether we just need to get it set on the trial calendar at that point. Mr. Zaid, any other dates that I can address for your side here today?
Good by me.
Mr. Carvajal?
Nothing, Your Honor. Thank you for accommodating us by Zoom.
Agreed.
All right, again, the court will send out notice of that, the pretrial order along with the notice of the date and time of that next status conference. And you're both free to disconnect. Thank you.
Thank you.
Thank you.
All right, and we'll go on the record now in Paley versus Lane. This is file number 2511914. And if I could have counsel put your appearances on in that file, please.
Good afternoon, Your Honor. Gregory Light for the plaintiff, Michael Paley.
Good afternoon, Your Honor. Kaylin Piper on behalf of Pioneer Insurance Company.
Good afternoon, Your Honor. Anna Katz on behalf of defendant USSIC.
Okay, this is set for a status conference in this case today. Mr. Light, on behalf of plaintiff, can you kind of tell me where things are at?
Sure. My client's deposition was just taken on February 16th. And although we did agree with a mediator, Kathy Nash, and that was provided to the court, to be perfectly honest, I think maybe the right hand thought the left hand was securing dates and vice versa. So we don't have dates, but we've reached out to her recently for dates, and we do want to go through the mediation process. And from my perspective, I'm sure defendants too, whatever extra time I think we need to get that accomplished, I'd like to have discovery open. But I'm certain that, mediation would be fruitful and we would like to proceed with that.
Okay, Ms. Piper?
Yes, I certainly agree with the statement made by Mr. Light here today.
Ms. Katz?
I also agree with Mr. Light.
Okay, Mr. Light, what kind of time frame are you thinking about for, I'd like to set a realistic time frame here for the parties to get mediation completed before we meet again.
Could 90 days just to be sure, because I don't know what Miss Nash's schedule is. Maybe
I can help with, yeah, I can help with that. So the last I knew is Miss Nash was scheduling out into May and June at the earliest. So we'll have to coordinate with our calendars certainly as well. So maybe a little bit more than 90 days, and we should certainly be able to get that done.
All right, if I set this for another status conference in July, it sounds like that would be within that period that the mediator's indicating. Does anybody have an objection to that?
No objection from plaintiff.
No objection.
Thank you.
All right, so I will set this for a status conference in July. If the case settles through mediation, then just notify the court and we can take that status conference down. Other than that, Mr. Light, are there any other scheduling matters I can address for your side today?
No, Your Honor. I'm getting along great with both defendants. We're working, amicably. I'm fully confident that, like I said, that we can settle this through mediation and notify the court of same. But I'm satisfied right now with how things are going.
Thank you, Ms. Piper.
Agreed and nothing further. Thank you, Your Honor.
Ms. Katz.
Nothing further. I just had one quick question with the extension for mediation. Is there a way we could extend discovery? Not by much, just a little bit, as I know it closes today.
Yeah, I think that was part of your request, right, Mr. Light? So you don't have an objection to that?
Yeah, no objection. I think it's fair for all parties that it stays open up until that time because I just had my client's deposition. There may be some additional things, depositions that need to be done before we mediate.
All right, so I will include that in the status conference order as well.
Great, thank you.
Okay, I will send out a status conference order that reflects what we've discussed here today, along with the notice of date time for that hearing in July, and all council are free to disconnect. Thank you.
All right. Thank you, Your Honor. Appreciate your time.
Thank you.
Sorry, I missed that whole case. What did you do on the Elders?
I did kind of a standard trial.
No, just kind of a.
All council present trial. Okay. right, looks like we've got everybody connected. So we'll go on the record in file number 2511839. The estate of Smith versus William Smith. And we have Mr. Isles on behalf of plaintiff present here in the courtroom. I see Mr. Giroux connected by Zoom on behalf of plaintiff and Mr. Lobello on behalf of defendant. This is set for hearing today on plaintiff's motion for summary disposition. I did have an opportunity to review the briefs of both sides, as well as I read through all the deposition testimony that was submitted and all the other exhibits. So I'm familiar with the facts of what happened here and the arguments of the parties. Mr. Isles, did you or Mr. Giroux want to handle our?
Mr. Giroux is going to do that today, Your Honor.
Okay, so Mr. Giroux, is there anything you wanted to state by way of oral argument in support of your motion?
Good afternoon, Your Honor. And I don't believe so. If this court received on Monday our reply, which was basically all the rebuttal arguments, and was able to see the affidavit of the witness and I think the court indicated it did read the testimony of the defense expert and the trooper who did the accident investigation and reconstruction. I don't have anything to add to all of that. I'm sure the court noted all of the testimony and the evidence and the proofs. I would just like an opportunity to respond to anything that defense counsel has to say, but that would be very brief.
All right, thank you. Mr. Lobello?
Your Honor, I believe our brief also covers all the arguments made by the plaintiff. Just to add briefly, I believe this is a matter of weight and credibility. With regard to the deposition testimony and Mr. Smith's statements. In addition, Your Honor, there doesn't appear to be any authority provided by the plaintiffs with regard to their intent to seek a claim under the No Fault Act. I believe that the Hardy case covers that issue in detail. And with that, Your Honor, I would submit to any questions that the court might have or respond to Mr. Giroux's arguments if need be.
All right, I guess, Mr. Giroux, I did have one question on that issue of the complaint. So I mean, I reviewed the complaint. It doesn't cite either the Wrongful Death Act or the No Fault Act. It's pled as a claim for negligence.
Yes, it is a claim for negligence, Your Honor.
Yeah, so my question, looking at MCL 500.31352A, which is the provision that you cited in your motion, you're in asking the court to find summary disposition that your client is entitled to no non-economic damages under the No Fault Act. When I read that provision, to me, 3135-2A deals with the court's determination, either a question of law or a question of fact, as to whether or not a plaintiff has suffered a serious impairment or a permanent serious disfigurement. In this case, we're dealing with somebody who suffered death. So to me, it's really irrelevant. That provision 2A is irrelevant because we're not dealing with whether or not there's a question of fact on an injury here and whether it qualifies for non-economic benefits. So I guess I don't understand fully what your argument is. And in any case, that provision wouldn't call for a finding that a plaintiff is entitled to non-economic damages. It would just be a finding that as a matter of law, there's no question that they've suffered an injury that would qualify for those kind of damages under the statute. So can you clarify for me exactly what you're asking for there?
Yes, Your Honor. Again, the reason we pointed that out in the law is because historically, prior to the existence of the No Fault Act in the state of Michigan, obviously we were dealing with just a straight form of negligence law. And every party who felt that he or she was harmed by a breach of the ethical standard of care or a breach of ordinary care or failure to follow ordinary care, which is the definition of negligence in Michigan, they could file a negligence claim. Then comes the No Fault Act, and it basically is supposed to be an all-encompassing act, except under 3135, where it says, so the No Fault Act provides immunity for anybody who's driving his or her car that is insured. They complied with the law, they got their insurance. They're immune from many things. They're immune from being sued for wage loss, except for excess wage loss. They're immune from being sued for medical bills. they're immune from being sued for certain things that you could get in an ordinary negligence case. However, under 3135, a driver does not have immunity. They don't have that protection for any injured person who has suffered one of the threshold injuries. So that's the only purpose of citing that statute, is to say that the defendant is immune from certain types of damages, including medical bills, everything that's covered by the No Fault Act. We could not sue the defendant for and have not. We can sue, and you have to look at both statutes, 3135 and the Michigan wrongful death statute, when you get to the damages portion of this case. Some of the damages under the Wrongful Death Act we are allowed to get, because you have to look at both statutes in conjunction. Some of them we are not allowed to get. And so that is the only point of that citation or that statutory reference, which is that the defendant does not enjoy total immunity. The defendant only enjoys immunity for those things that are covered under the No Fault Act. And he doesn't enjoy immunity because the decedent suffered, or the injured party suffered, one of the three identified threshold injuries. That is all, Your Honor.
Yeah, so I still don't know what you're asking me to rule on today, though, because it seems obvious that your client suffered death, so your client has suffered one of the threshold injuries.
Yes, so we're asking you to rule on the negligence portion of our claim that's identified in the lawsuit, and the liability portion of that, which would be, did the defendant fail to act with ordinary care? More specifically, did he violate the statute that says you have to basically drive at a reasonable speed, such that you're not driving too fast for conditions and lose control of your vehicle, which is a presumption of negligence, and also consider the fact that there are no available defenses to rebut the presumption of negligence, because not only did the state trooper testify unequivocally, this is not a sudden emergency case, which would be the only way to excuse a violation of the statute. He testified unequivocally, this is not a sudden emergency case, because the snow and ice had existed all morning and for many, many, many miles, and it hadn't changed. The defendant's own expert that the defendant's attorneys retained agreed and said, yeah, the only cause of the accident is that Mr. Smith, unfortunately, was going too fast for conditions, and that he could not identify any sort of sudden emergency that existed in this case. So then why would we go through, and the whole purpose of motions for summary disposition is to streamline cases like this. If there's no question of fact on a particular issue, why take up the court's time? Why take up the jury's time? Why not hone in on those things that actually are in contention? And here, even if the defendant's affidavit were available in paragraph 5, it clearly says that the icy conditions remained. And the definition, the plain definition in the dictionary is for remain is continues to exist. So over the course of case law in the state of Michigan, particularly on this issue, under a case like this where a driver is experiencing icy road conditions for many, many miles, there has never been a case that has upheld a defense like a sudden emergency, because it's not sudden. It's well known. It was well experienced. And the only explanation in this case by all of the witnesses, fact witnesses and the and the expert witnesses, is that unfortunately the defendant made a mistake and was driving too fast for conditions, because there's no other explanation for the crash. So we're trying to shorten up the trial. I'm trying to avoid repetition of testimony and factual recitations when the facts of the case are very straightforward and simple. And I think it would be just to grant this motion on the issue of the defendant's negligence, because there's no question of fact, and let the case go to the jury on the issue of damages, whether or not something else, I guess, was a proximate cause of Mrs. Smith's death, if that's what the defendant intends to do. But that wouldn't mean that Mr. Smith's negligence was also a proximate cause, because clearly it was. We submitted the death certificate, and no one has ever contended that the death is not directly related to the crash.
Okay, go back to my original question on the no fault act part of your motion though. Are you asking me to make some kind of ruling specifically under the no fault act?
No, Your Honor, we're just making sure
Okay.
that it's clear that the defendant doesn't enjoy that immunity as it relates to those particular damages that are allowed in this kind of case.
Okay, all right, thank you. Mr. Lobello, anything you wanted to say in response to what Mr. Caruso had to say?
Yes, Your Honor. And again, I think that perhaps the most instructive interpretation of the sudden emergency defense as it applies to this case comes from actually Mr. Jabru's brief itself on page 15. One who suddenly finds himself in a place of danger and is required to act without time to consider the best means that may be adopted to avoid the impending danger is not guilty of negligence if he fails to adopt what subsequently and upon reflection may appear to have been a better method, unless the emergency in which he finds himself is brought about by his own negligence. Your Honor, the statement that we provided from Mr. Smith indicates that he adjusted his speed not once but twice, and simply because he adjusted his speed either not enough or not to whomever's standard it might have been necessary is for the jury to decide. But that fits squarely within the definition of the sudden emergency, is that in spite of Mr. Smith's reasonable care that he exercised prior to this incident, he was still unable to control the vehicle nonetheless due to the sudden icy conditions. It's been held in both the Young versus Flood case and the Marciano versus Booth case, as well as for the court's candor, upheld by the Court of Appeals as recent as 2022 in Cousineau versus Cousineau, and that's WL 17111-703, Michigan Court of Appeals, May 26th of 2022, that is a standard by which, or I'm sorry, that the icy conditions, even though existing for some time, may still present themselves suddenly in order to create the sudden emergency that we're claiming here in this case. So, Your Honor, again, I believe Mr. Smith's statements regarding his actions prior to the accident, in spite of however much the plaintiff's counsel may disagree with them, create a question of fact for the jury to decide in terms of whether or not his actions were reasonable prior to this accident occurring, and whether or not he was the proximate cause of that accident. And again, there's indication from Trooper Stone that the seatbelt did not lock in this case. And unfortunately, I just noticed this the other day, but Trooper Smith's deposition was taken on October 22nd, 2025. He was then listed as an expert by the plaintiffs on October 28th, 2025. So in terms of the basis for Trooper Stone's knowledge to be able to comment on the seatbelt issue or the airbag issue, I don't believe those facts are in evidence to qualify him to do so, Your Honor. But again, that's a matter of admissibility of that issue as opposed to whether or not the court should rule as a matter of law whether Mr. Smith is at fault wholly for this accident.
All right, thank you. So again, I did have a chance to read through all the written materials. The arguments of counsel here today have been consistent with what they submitted to the court in writing. As both counsel are aware, the court has to view all the facts in a light most favorable to the defendant as the non-moving party here. In order to grant summary disposition for plaintiffs on the issue of liability, the court would have to find that there's no genuine issue of material fact. In other words, that no reasonable juror could find in favor of the defendant. Looking at the case laws cited by the parties here, number one, the court finds that the parties are correct in their assertions under those cases that the jury can infer negligence if it finds that there's been a violation of a statute, whether that's a civil infraction or a criminal charge. And it seemed like all the opinions here in this case were that the defendant was driving too fast for conditions based on the data and the information available. So a jury, I think, could infer from that because the defendant was driving too fast for conditions, if they accept that opinion, that the defendant was negligent, but again, under those cases, that inference can be rebutted or removed by a situation where there's some type of acceptable or reasonable excuse for the violation of the statute. And one of those is the sudden emergency doctrine. And that requires that there be some type of unusual or unexpected condition. Unusual is defined by the cases as varying from everyday traffic conditions. Unexpected is a type of condition that appears so suddenly that normal expectations of due and ordinary care can be modified or disregarded because of the nature of that unexpected condition. And looking at the Young case and the Amick case, which both indicate that in Michigan in the wintertime, snowy and icy conditions aren't necessarily unexpected or unusual. They persist for a large part of the year, particularly depending on what area of the state that you're in. And so that doesn't necessarily give rise to an unexpected or unusual condition just by virtue simply of roads being snow covered or having ice or generally wintry conditions, which can make driving hazardous. And that's, I think, kind of plaintiff's argument here is this isn't an unexpected or unusual condition. Defendant should have anticipated potential hazards and used due care, driven at a reasonable speed, given those conditions. And had he done that, this accident wouldn't have happened. But I think those cases also make clear that there's a distinction factually between the type of situation, I think, which was in existence in Young and to some degree in Amick, involving an assured clear distance type of violation where a person is following too close, hits a patch of ice, and slides into another vehicle, in which case, you know, in that situation, it's much more reasonable to expect that that person has to anticipate that something could happen in between when they start to brake and when they encounter the car in front of them. And they need to keep enough distance to take into account potential snowy or icy conditions. Versus a situation where a person hits a patch of ice and crosses the center line, and where a driver is going at reasonably prudent speed for conditions, but nonetheless still hits a patch of icy road and the car skids and crosses the center line and hits another vehicle, that could give rise to an unexpected or unusual condition, because even in those snowy conditions, that in and of itself wasn't expected. And depending on other factors, even in snowy and icy conditions, particular patches of black ice or so forth that cause a person to lose control, even though they're otherwise exercising due care for those conditions, could be a sudden emergency that would or could rebut that inference of a finding of negligence by violating the statute. So when I look at the specifics of this case and the testimony of the troopers here, I mean, they all kind of acknowledge that it's the default position that any accident that arises from a car sliding or skidding or losing control in snowy or icy conditions, their default position is that it's too fast for conditions. And that gets written up in every report. And it's not based on a specific, you know, analysis of that particular accident. It's just kind of, we had a car slide, lose control, there's icy and snowy conditions. It gets written in the report as too fast for conditions. And Atkinson in his deposition even acknowledged that, hey, we put this in every report, but ultimately it's up to the prosecutor, or if it goes to a lawsuit situation, a judge or a jury to decide whether that person was actually going too fast for conditions. And I think Trooper Atkinson even alluded to the fact that it depends on, you know, the specifics of the community where it happens, whether people generally view that as a true accident or whether it's something that the person should be held liable for, either criminally or civilly. And so I think what Atkinson points out is really what we have here, which is a true fact specific kind of question here and opinion that calls for determination by a fact finder. And that the default position by the troopers based on the conditions and the fact that the defendant lost control is that it doesn't necessarily mean liability in all circumstances and in all under all conditions. So there's that, which in my view gives rise to a question of fact for determination from a jury about whether or not, in light of the fact that the troopers write it up as a loss going too fast for conditions, whether or not it truly was under those circumstances. The other thing is, you know, when you look at some of the other facts surrounding this, the only data that they had from the FJ was that it was going maybe 73 miles an hour, but the testimony as to the EDR results was because of the spinning of the vehicle and so forth. They could never really nail down with any certainty what the speed was, but that was the only number that was available. Trooper Stone at page 26 of his deposition testified that the data they had from the Silverado was that it was going 69 miles per hour. So, you know, was Mr. Smith going too fast for conditions if he was going 73 and the Silverado was going 69? I mean, those are fairly comparable speeds. So even if Smith was traveling slightly faster than the Silverado or other people that he passed on the road that day, how much faster was he going? And is that too fast for conditions when the Silverado was going 60 miles an hour? And so, again, this isn't an assured clear distance issue. This is more in the line of the hitting a patch of ice and crossing the center line issue. And so even in snowy weather and even going at that speed, is it reasonable to expect that you know, Mr. Smith, to expect that he was going to hit ice when he was going generally at the same speed as other vehicles on the road at that time? Maybe it was, you know, I mean, he was going over an overpass and there are warning signs on overpasses. And so is it more reasonable to expect that he would hit ice on an overpass? And as I was going through this kind of back and forth in my mind, considering this motion, and I find whenever I'm doing that, when I'm looking at facts, and if I'm going back and forth and I can see both sides of this, what that tells me is that there is a genuine issue of fact here, and that a reasonable person could conclude that Mr. Smith wasn't going too fast for conditions, and that hitting that ice was unexpected at the time that he hit it and in the way that he hit it, given the way he was traveling and the other vehicles were. But I think a juror could absolutely find that common sense says you're going over a overpass in snowy conditions like he was that day. You need to slow down or be ready for possible slippage. So I think jurors could go either way on this, and because of that, I think there's room for a question of fact here. And again, I have to look at everything in a light most favorable to the defense here and the non-moving party. So for all of those reasons, I do find that there is a question of fact as to liability, and in particular, whether or not the sudden emergency is a viable defense here. So the court is going to deny the motion for summary disposition. And so, Mr. Drew, as the moving party, I would request that you prepare an order that reflects the ruling of the court today and submit that under the 7-day rule.
Yes, Your Honor. Couple of things, if I may. Is that a decision with prejudice or without prejudice? And the reason I state that is because the defense has been using an affidavit that is not signed and not admissible at this point in time. In fact, the defendant didn't have any admissible evidence that he responded to the motion with, which is required under the court rules, MCR 2.116 C10. And if it turns out that that is not the testimony from Mr. Smith and or the affidavit never becomes signed, I'm wondering if that makes this a situation where your denial would be without prejudice, so that it may be raised again. If not, that's okay. I just am raising the point for clarification.
Sure, yeah, and I guess to clarify my ruling, I'm basing my decision on all of the exhibits that were submitted with plaintiff's motion. I'm not basing it on any of the information that was provided by defense. So I'm going on the deposition testimony that was attached to plaintiff's motion. So
Thank you for that
to that
clarification.
extent, I'm not relying on that affidavit. So
Very good. Thank you, Your Honor.
okay, thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Thank you.
Thank you, Your Honor. And just briefly before we disconnect, can the court verify that Mr. Smith is not in the courtroom today?
Mr. Isles is the only person present here with us,
Thank you, Your
except for
Honor.
my court officer and the clerk.
Thank you, Your Honor.
Okay, thank you. All right, Mr. Sarah, are you able to hear me okay?
Yes. Yes, Your Honor. Oh,
Thank
sorry.
you. Miss Sarah, are you there as well?
Yes.
Okay, we're on the record in Sarah versus Sarah. This is file number 2311355. The record should reflect both parties are present today. This hearing was set today at the request of Mr. Sarah. Mr. Sarah, what is it that you'd like to state today?
I would like to go ahead and see a final an end to we went through mediation to try to reach an agreement on several topics which you had forwarded to the mediation group, and we did not meet a resolution on any of them. And after talking to the director of the mediation services, she recommended it go to the judge because she could not solve the mediation disagreements.
Okay, so what are you asking the court to do?
Make a judgment on several points. The mediator had forwarded to your office her findings.
Okay.
And I'd just like to go over them point by point so we can finally reach a resolution on a lot of these points.
Okay, why don't you tell me what the first point is you'd like to address?
The first point was, let me see, I don't have a printer anymore. I have to look off my screen. It says Jody, Sarah, and Stephen Sarah have reached partial agreements on the following. Jody agrees to deliver the 2013 Toyota Highlander vehicle titled to Stephen Sarah, agrees to sign the title immediately to remove his name from the title and mail back to Jody, which I did sign the title. I received it on the end of at the end of January. I have not received any indication from Jody as to whether or not that has been submitted to the SOS to take me off of the title. This has been going on for a couple of years now.
All right, Miss Sarah, have you got that title to give to Mr. Sarah?
Not to give to him. I have the title in my name.
Okay.
Now, part of the resolution was I was to receive proof that I had been removed from the title, which I have received none.
All right, what proof do you want?
Yeah, exactly. For what? Well,
My address, Your Honor, my
Miss
address
Sarah,
is on.
Miss
all this
Sarah, hold on. Miss Sarah, we're
Sorry.
gonna do this one at a time. I asked Mr. Sarah a question. I didn't ask you for input. Mr. Sarah, what do you want from her to prove?
I would like a copy of the title or at least a photograph of the title with my name removed, because as of now, I'm still on the title and as such responsible.
Okay, Miss Sarah, can you do that?
It's been done, Your Honor. I have the title in my hand. Problem is, it has my address all over it, and I don't want him to have that.
You can delete that. You can marker that out, or if you have Photoshop, you can easily eliminate your address. I don't care about the address. I just want to see a clean title with my name removed, which I have not, Your Honor.
Sarah, can you send him a copy of that with his name off of it?
Right there, sure.
Okay, next point, Mr. Sarah.
Jody and Stephen both agree that neither are in a position to make payments or pay in full the student loan debt. Stephen
Stephen has
agrees
nothing to do with that.
Okay,
Pardon
Miss
me?
Sarah, Miss Sarah,
Sorry. Yes,
I'm not gonna keep telling you this.
okay.
Please don't interrupt. When I need a comment from you, I will ask you. Go ahead, Mr. Sarah.
Stephen agrees to try and contact student loan carrier to see if they will take payments from each, Stephen and Jody. I did, and they will not. They expect the loan has actually gone to a collections agency, so it is out of the hands of the student loan debtor, and it's now in a collection agency's hands. And I assume Jody are in the same boat where this is a $250,000 loan. Neither one of us can either make payments or pay off it in full. We each bear half. So as of now, it just stands where it is. I believe as much as I would like Jody's half of the student payments, I can't make them myself, so I can't. I'm at a quandary on what to do on this. So as far as the mediator goes, this was basically at a standstill, and it's not exactly a negotiation between Sarah and I.
Okay, so what are you asking to do about that?
Honestly, I am in no, I don't have the money. They want for a $250,000 loan, they want twice what I pay on a mortgage. I don't have it.
I
So,
understand that. Well, what are you asking me to do about it?
well, they're threatening to take part of my Social Security. So if they do, which they have not yet, I collect Social Security. They have not yet taken part of that, but if they do, I would like to reduce the amount I would owe to Jody, because it's in part of my payment for the student loan. I know this is convoluted and I didn't make sense. I'm sorry.
No, that makes sense, but that hasn't happened yet, right?
No, it has not. They just sent me the letter saying they were going to I forgot the legal term, take part of my Social Security payment. And I don't know how much it will be. They did not give me an amount.
Okay, so that, I guess that's a bridge we'll have to cross when.
That is exactly true, sir.
Okay.
The next item was Stephen agrees to owe Jody $2,061 for 2 vehicle payments in March and April of 2025, insurance payments $325 and $425, and a March payment for the pension, which is my part of the pension is $928. I believe Jody receives $933. My question to the court, Your Honor, is for those months of March and April, I was paying $1,000. Jody did receive a pension for one of those months, but in addition, I'm to make auto and insurance payments, and that adds up to a lot of money that I just don't have. And I don't understand. Maybe the court can explain if I am truly responsible for, at the same months I owe auto payments and auto insurance, I'm Ms. Sarah is receiving half my pension and $1,000 cashier's check. So she's receiving, I believe, more than she is entitled to for those 2 months. What I would like to see is the two vehicle payments and the insurance payments knocked off. I did pay $1,000 and per month, which she received, and she did get 1 month's pension payment, which would make me responsible for 1 month's pension payment of $933, depending on if, like I said, I get $928, Jody gets $933. I don't understand. I'll pay her the $933 for the month I owe her, but I would like to see the two vehicle payments and insurance payments seem to be more than I'm owing for those 2 months, and I don't understand.
Well, this says in the last sentence of that paragraph, this says these funds will be deducted from the payment for the firearms. So those are going to be credited. So
Correct.
It's not an amount you have to pay.
Whatever the court decides, I will abide by.
Well, I'm not deciding anything. I'm just going by what the agreement says. It says you owe that much, and it says these funds will be deducted from the payment for the firearms. So that's money that Miss Sarah is not going to have to pay you for the firearms. That's how that's going to be equalized.
Okay, agreed. The next paragraph, Stephen agrees spousal support of $1,000 per month has been paying regularly from March through April, November 25, which was the last time we had the mediation, I believe. Stephen agrees to continue paying $1,000 per month until Jody is eligible for Social Security, which at this time is scheduled for July of 2026. So I have kept my agreement, and I have been paying $1,000 per month, which I don't believe is contested at this point and is scheduled to end. Jody turned 62 in June of 2026. So that should be my last payment to Miss Sarah.
I will start getting Social Security in August. I'm sorry to interrupt.
Okay. All right, Mr. Sarah, what's the next thing then? That sounds like that's taken care of.
Okay. Jody and Stephen agree Jody is receiving the pension directly from the company on a regular basis. And I don't believe that has changed. So Jody is receiving her pension payments directly from the company.
Okay. All right.
It's the next one is there's only two more. Stephen and Jody do not agree on the value of the firearms and would like a determination of those items. Stephen claims the value of the firearms listed on the exhibit are not the current value, but what he paid for them many years ago. Stephen also claims the list is not complete. There were many guns not listed, such as a 1911 pistol. I will add AR-15 was not added. A couple of black powder guns were not listed, although my son has custody of those. I don't have a problem with that. And many assorted BB and pellet guns. Jody claims to not have the guns, but is aware the judge has ruled she is to reimburse Stephen. Now, the last time we were at mediation, she did not agree that she owed me money for these. And that for me is the main outstanding exhibit for today, that Jody is in fact responsible for those firearms that's set forth in the divorce agreement. As far as them being not of the value I would like, I'd like, in the divorce agreement, it says she will pay the value of the firearms. That's just a sticking point, whether the value is what that piece of paper, which was for the ATF, was just a registration, and the price I paid for them at time of purchase, and not necessarily the value of those firearms. Although I have not submitted anything to the court otherwise. So Your Honor, I guess I'm asking that Jody agree that she does owe some money for the firearms, whether or not it was the declared value to the ATF or the true value of what they were worth at the time they were stolen?
Okay, well, I'm looking at paragraph 5 of my ruling on the divorce. And that's on page 9 of my ruling from last February. And that says that the court awards to the defendant all the firearms listed in defendant's exhibit I, which was admitted by your attorney, Mr. Sarah, during the trial.
Correct.
Which the plaintiff must have returned to him. So number one, that means any firearms that the plaintiff has or has within her control through your son or in any other way, they have to be returned to you. If any of those firearms have been disposed of, or in other words, sold, or just gone and can't be returned to you, then the defendant is entitled to receive the value of those firearms according to the values listed in defendant's exhibit I. So I've already made a decision on what those values are, and the values are what they were listed as in your exhibit. So we don't have to decide the question of value because it's going to be according to that. And so Miss Sarah either has to give you those back or she has to pay you those values minus the amounts that you owe her under the mediation agreement for those March and April payments. So those should be deducted from the amount that she has to pay you for any firearms that she can't return. So to me, that answers the question of what needs to happen. And any other firearms that weren't included in your exhibit, I mean, that's water under the bridge. That's too late now. That should have been something that was brought up by your lawyer at trial. So, Miss Sarah, I don't know how many of those guns you still have or your son has, but you need to either return those guns to him or pay the amounts that are in that exhibit. Do you
Can I ask
understand
a
that?
question?
Sure.
How do I return the guns to him safely, keeping me and my son safe, and get him to admit that we gave them to him? Because he told my son could sell them all and keep the money, or he could return them and he would say he never got him. So
Well,
where am I
about
supposed
any
to
of
go?
that? And I don't, again, as I've told both of you before, my job is to make decisions in this case. It's not about how to give you advice about how to carry out those decisions. So you're an adult, you're fully capable of figuring out a way to return what needs to be returned to him or pay him the money. And so you need to do that.
Can that be done in the court parking lot?
That's not up to me.
Okay. All right.
Again, you're both adults, you're fully capable of figuring out how to arrange for that transaction. But that's not part of my job, is to tell you what to do, what not to do. Because I'm not going to be responsible for what you guys do or don't do.
Okay. Can I ask what the total was again?
I don't have that exhibit in front of me, but you should have that in your materials.
Okay.
So that addresses that issue. And I'm gonna give you 60 days to do that, Miss Sarah.
Okay.
Okay. And Mr. Sarah, you said that's the last issue that you have, correct?
There was one more, Your Honor. The last item was Stephen and Jody agree there's still some of Jody's property left in the marital home. Jody agrees to find someone to go to the home for her with boxes, tape, packing materials to retrieve these items. Jody agrees to send Stephen an email regarding the time frame for the pickup. Jody agrees Stephen at least 1 week notice. My only issue with that, and I did give a guidelines for moving document to the mediator which I know Jody should have gotten a copy too. I believe I copied her on it. Basically said if she can't come up with people to move stuff out, I would pack her items or pack items very carefully and work with her movers under the guidelines for moving. Basically, the guidelines for moving were just basically for my safety and hers and Jody's. I don't expect her to be here. She'll designate movers. And I will go ahead and box up the final items that Jody had left here. My question to the court would be, it's been over 3 years. I agree to return items, but it has been over 3 years that she abandoned this property that I've been taking care of. My question to the court would be, is Jody still entitled to these items? But again, I said I'd go ahead and return what I can return.
I think if they're her things, yeah, it doesn't matter how much time has gone by. If they're hers, they're hers, so she should get them back.
Thank you.
And the agreement is that there's still some of Jody's personal property left in the marital home, and looks like at mediation you agreed to return those things to her. So, and I think this last paragraph in the mediation agreement is a very reasonable method for having that done. So, does that answer your question, Mr. Sarah?
Yes, it does, sir.
Okay. All right, so I'm going to put these things that we've discussed here into an order. I will send that out to the parties. And that's all we have for today. Thank you. You're both free to disconnect at this time.
Thank you.
Thank you, Your Honor.